Let me spend about 20, 25 minutes with you, if I could, talking about three things. I want to tell you a little bit about myself, why there's a lawyer from Texas up here talking to you here in Nebraska. I want to talk to you about what we've learned that Syngenta did that we think we can prove played a role in the drop in your corn prices and the income that you lost as a result. And then lastly, there's some papers on the table in front of you. I'll take you through those and explain to you what the steps will be if you choose to join this lawsuit, and then we'll just open it up for any questions you got, okay? As Nate mentioned, I'm Michael Watts. I'm from San Antonio, but I don't spend much time there. I don't spend much time in the state of Texas because what I do for a living is I go around the country and I get hired by other people to try their lawsuits. I spend time in the courtroom, okay? I represent a whole bunch of little folks. I represent a whole bunch of big folks. I represent farmers. I represent companies. But my entry into this area of representing farmers kind of happened by accident about 7 or 8 years ago. I had a lawyer that worked for me that was good friends with another young lawyer in a firm in San Antonio, and that young man's father was a rice farmer in Arkansas. And between 2005 and 2006, he had made the same quantity of crop between the two crop years, but the amount of money he got from his rice had fallen by a factor of 2 or 3, and the ends weren't meeting, and he was upset about it, so he asked us to look into it. And this other firm and I got together on this case, and before you knew it, we represented not only him and all of his neighbors, but his neighbors' neighbors and the people in the town next over, and next thing you know, we started having meetings like this. And by the time we were done, we represented almost 4,000 rice farmers against a company called Bayer Crop Sciences. And what they had done was they were doing some testing of a genetically modified trait of rice that was not yet approved for human consumption. During that testing, through the concept that you guys know as drift, that unapproved rice got from field to field to field and farm to farm, and before you know it, it had infiltrated the entire United States rice crop. We produce more rice than we consume here. When we tried to sell it on the export market, a number of our export partners have different rules than we do on genetically modified products, and they refused to buy it. The export market crashed, and the farmers lost billions of dollars, okay? Fast forward over several years, there were 6 cases tried. The farmers won all 6. My partner in that case and I were getting ready to try the 7th. It was a dangerous case. Bayer came to us and they said, look, we want to talk about settling this case. So I spent a couple of months personally negotiating the first of 2 documents, which became the basis of a $750 million settlement of those cases against Bayer. Ever since then, the idea of an agricultural tort has been paramount in our minds, okay? So let me tell you how we got involved in this Syngenta case. The bottom line is that it's a little more personal to me than the rice case for this reason. While I have to confess to you that I was born into a family of lawyers. My dad was a lawyer before he retired. My mom was a lawyer before she became a judge. I had the good sense to marry into a family of corn farmers. My wife's family came over from Germany in 1905. They've been farming the same plot of land in South Texas for 109 years. Until last year, we got a call from her cousin who had seen his farm foreclosed on by the bank. And I got involved to see what we could do to rescue it. When I looked at the books, it's just like what we learned in rice. He'd made the same crop last year he'd made the year before. It was all about the money he got for it. And so it was like a light went off, and I said, this is happening again. So we started digging in. And over the course of the next year, we did a lot of research. And here's the things that we know. Number one, Syngenta is a Swiss company. They're the world's 3rd largest seed company. In 2009, their engineers had developed a genetically modified trait of corn that they called MIR162. It was designed to fend off insects and corn borers and the like. They wanted to sell it here in the United States, but they did not yet have approval from some of our major export partners like the European Union, China, and some others. So when they came to the U.S. government and they said, we want to sell it here, they had a bit of a problem because there's some supply and demand issues here. You guys produce more corn than everybody can eat here. You produce more corn than all the cattle can eat. You can produce more corn than all the ethanol plants. And so we have a heavy supply situation. And when you have more supply than demand, we all know what happens, the price goes down. So the only way we could keep that price up to pay for that equipment that you all have to buy is a healthy export market. And so both Syngenta and the U.S. government knew about the importance of a healthy export market. So when Syngenta came to the USDA and said, we'd like to be able to sell this yet unapproved seed here, they made some promises to the government in order to keep this unapproved seed out of the export supply. Number one, they said they'd keep this unapproved seed that they were selling completely segregated from all other approved seeds, Pioneer, DeKalb, whatever. Number two, they made the promise that the farmers to whom we sell our unapproved seed, we will ensure that the corn that they grow does not get mixed in with other corns. And this is where it gets a little bit ridiculous. In their petition, they say, we'll stop cross-pollination. Now, I don't know whether anybody's driven across Iowa like I've been doing the last 4 months, but I've seen more wind turbines than anybody anywhere else in the United States other than Texas, and I've learned what a ground blizzard is. Blue as can be up there, can't see a thing in front of you because 60-mile-an-hour winds are blowing, snow so strongly sideways. I don't know how you keep seed from Farm A off of Farm B. I just don't know how you do it, but they said they would. They said that they could keep every farmer in America from commingling their corn with other corns. I don't know how you do that either. And then the bottom line is they said that they would see to it that the corn that was produced from their unapproved seed did not get channeled into the export supply. And at its core, this lawsuit is about those three promises they made and their failure to keep them. That's it. So what happened? Well, the U.S. government bought off on it, gave them preliminary approval to sell it here. They went over to China and sought approval over there and did not get it. I don't really care why that happened. I don't really think that's part of the lawsuit. What really happens is it comes back over here, and in Iowa, in southeast Iowa, a company that you're all familiar with, Bunge North America, had heard about this failure to get approval from China. And they buy corn from you and they export it. That's their business. And they said, well, look, I can't buy your corn if it's this unapproved corn because I won't be able to sell it. So they put up signs outside their grain elevator saying that. Well, even though Syngenta just 3 months before had been telling the federal government they'd do everything in their power to see to it that these corns didn't get mixed in together, instead of working with Bunge to solve the problem, they sued them. They sued them in federal court, claimed product disparagement, and sought a court order to make them take the signs down. They ran into a federal judge up there by the name of Mark Bennett, who was not very helpful to their cause. They never got the court order to make Bunge take the signs down. There were a bunch of documents produced in that case that are very enlightening. There are documents that demonstrate back in 2010 that Syngenta knew exactly what would happen if its unapproved seed and the corn grew therefrom got into the export supply. They knew the export market would implode. It even mentions rejection by China. It's like Nostradamus is writing memos back in 2010. They knew what would happen, and that's exactly what happened. So, U.S. government buys it. They get warned by this federal judge that there's an issue here. The American Grain and Feed Association, one of your trade organizations, sends out 2 different reports warning them not to do it. They go ahead and do it. They make $785 million in sales based off this Viptura AgriSure in 2013. So what happens? Well, in that year, they have about 3% of the market share. 3% of you grew it, 97% of you didn't. The 3% of you that grew it. You weren't told to keep it separate that year. You take it down to the local grain elevator. It gets commingled in. The grain elevator supply, put on rails, barges, whatever, down the Mississippi, gets to New Orleans, put on ships, and eventually it's discovered. On June the 10th of 2013, an agricultural writer by the name of Ethan Huff posts a story on an internet magazine called The Natural News, and he documented for the first time that China, on 3 different occasions, had detected the presence of this MIR-162 in export shipments of American corn, and they were destroying those shipments. A commodity that had traded consistently at about $7 a bushel throughout 2012 and the first half of 2013, all of a sudden takes a nosedive. On November the 19th of 2013, the Chinese just stopped doing the testing, and they turned around an entire ship. It was a Cargill ship, didn't even let it dock. Sent it away and implemented a ban on U.S. exports of corn. I'm getting a lot of head shakes. You guys read about it. It was not a banner day for the American corn farmer. Okay? That caused the price to sink even further to about $3.25, which is where it stayed most of last year. And in December, Syngenta finally talked China into approving it. Just the rumors about that sent DDG prices up, corn futures up, but not enough to recover the market. So the bottom line is billions of dollars of corn income that's just gone. Okay? So you've read a lot about this litigation. Let me tell you about it. As we were doing our due diligence, one piece of good news that happened, the very first lawsuit filed in the United States against Syngenta for this issue was filed by Cargill. The third one was filed by Archer Daniels Midland. Thousands of farmers, grain elevators, exporters have joined together to try to right this wrong. Some of the things we've learned. This is my 528th meeting with corn farmers. Okay? I've had a number of former Syngenta seed salesmen show up at these meetings, and they're just as mad as they can be, and not at me. They hear about what Syngenta promised the government that they would do to ensure that these farmers were told to keep it separate, and they said, I never said that. I never told the farmers anything like that. I was told to say, if I was asked, that there was no problem with the approval of it whatsoever. So there's a gap between what they told the government they would say and what got said. The reason for that gap is you start all the way at the top. We've got recordings of earnings calls where the CEO, Michael Mack, makes statement after statement after statement that makes it obvious there was no corporate leadership, no corporate intention to comply with those promises. He's asked on April the 18th of 2012, what are you going to do about this lack of Chinese approval? He goes, it's not a problem. We're expecting approval in a matter of a couple of days. Now, where I come from, that's just a white-out lie. He didn't have approval in 2012. He didn't have it in 2013. He didn't get it until December of 2014. And at its core, all this lawsuit is about is getting your lost income from the time that he said he had approval in April of 2012 until the time he got it in December of 2014. Okay? In ADM's lawsuit, one of the things that they allege is that at some point in time, Syngenta actually had a page up on its website that went something like this, concerned about lack of Chinese approval, click here for the approval documents. And you click there, and then it'd be concerned about lack of Chinese approval, right here for the approval documents. Well, some of those guys that were exporters actually wrote they wanted to see them. Of course, they didn't exist. They were trying to create the illusion that they had approval when they did not. All right? Bottom line is the price crashes. You guys, each of you know what happened to your pocket. You add it all up, it's a $6 to $10 billion claim. So the litigation. Each of you's got a couple of pieces of paper in front of you. Let me take you through that. The first one is a fact sheet entitled Syngenta's Role in Destabilizing the Global Corn Market. I've kind of already taken you through those facts, but the one thing I'd like each of you to do is grab that pen in front of you, turn that thing over to the back side just real quick. You see the address for the firm down there, Person, DeWald, and Deaver? Circle that address and just hold on to that, okay? Because I want you guys to take that with you. And the fact that you've got that and it's circled, it's going to become important in a second. That's really all I've got to say about that piece of paper, okay? What I want to do is I want to take you through the steps that would be involved if you choose to be involved in this litigation, okay? And that starts with the other document called a Contract of Employment and Consent to Fee Sharing. Now, what is this? Well, basically, our firms have to follow what's called the lawyer rules. Each state has a different title for them. I think they're called the Texas Rules of Disciplinary Procedure or something in Texas. I don't know what they are in here in Nebraska. They all say functionally the same thing. But lawyer rule number one is this. You don't do legal work for somebody that hadn't hired you in writing. This is that writing. Okay? If you choose to be involved, this is the permission slip for us to get started. Okay? Now look, I know your mailboxes are full of all sorts of people wanting to be corn farming lawyers and they've never been in a cornfield in their life, but that's okay. Some of them got contracts 35 pages long, a bunch of Latin in there to show you how smart they are. You probably already figured out that I tend to speak plainly. If I can do something in a half a page with 7 paragraphs, I'm not going to waste the trees on 30 pages to impress you. Okay? So let's go through this half a page and the 7 paragraphs. It's pretty simple. Paragraph 1 talks about the firm's authorization. And basically, you're giving us authority to represent you, if you choose to do so, in the lawsuit against Syngenta. You're telling me to use my best professional judgment to do what's in your best interest unless you specifically instruct me otherwise. Let me give you an example. It may seem easiest to file a lawsuit right here in your hometown, but there's what's called diversity of citizenship. You're an in-state plaintiff suing an out-of-state defendant, so it's going to get removed to federal court. And there's a law called the Multi-District Litigation Act where all of the cases are going to be consolidated in one court in Kansas City in front of a John Lungstrom, who's a good guy, okay? But, about 1,500 lawsuits have been filed there. About 11,000 lawsuits have been filed in state court in Minnesota. You can file in state court because that's the state where Syngenta's U.S. base of operation is. It just so happens that it's my professional judgment that that's a better venue for several reasons. Different jury rules, different evidentiary rules. You guys are the third largest corn producing state in the United States. Minnesota is fourth. The entire economy is based around corn. Most of the people that live in Minneapolis have family members that are farming out in the outstretches. We think it's a superior venue. But if one of you guys is a big time Chiefs fan, or you love the Royals or whatever, and you really want to be in Kansas City, right? File in federal court and I'll do it. Okay, we filed about 250 of them there. It's fine. But otherwise, I'm going to use my best professional judgment and file it in Minnesota. So that's basically what paragraph 1 says. Okay, that's an example. Paragraph 2, client cooperation. Getting past all the words on the paper, really what that says is you're going to help us get the documents that we need to prove your damages. Let me tell you what I mean by that. At its core, basically your claim is, hey, I produced X number of bushels. I would have gotten, $7. Now I'm getting $3.50. Syngenta caused part of that drop. Okay? I know that's oversimplified, but the bottom line is we're going to have to prove how many bushels of corn you made during the price drop. Okay? Now, how do we do that? Well, I could put you on the stand and get you to testify whatever you produced in 2013. I produced 100,000 bushels in 2013. And of course, I would believe you because in 25 years of practicing law, I've never, not once, had a client tell me anything but the full truth, okay? But Syngenta's not going to take your word for it, okay? They're going to want to see documents, all right? So we're going to have to get documents proving how many bushels you produced in each of these crop years. So what are the documents we're going to need? You might want to write these down. There's 3 of them, okay? The first document we're going to need is the Farm Services or the FSA Form 578. Now, what that does is that is a certification as to how many acres of corn you produced in each of these crop years. FSA Form 578, okay? Now, I can use the county yield averages and extrapolate out what your, what the average productivity in this county is, right? Now, there's 2 problems with that. Number 1, it just so happens that whenever somebody hires me as a lawyer, they cease being the average farmer in the county and they are all the most productive farmer in the county. And they don't want what that guy across the road got, they want what they lost, and I don't blame you, okay? I'm just teasing you guys, but the second problem, and this is the big problem, is those county yield averages, as you well know, they tend to lag by 2 or 3 years. They don't show what you're actually producing. They showed what you produced 2 or 3 years ago when the technology wasn't as good, okay? So we're going to want to get your actual yield. What do? Well, most of you have banking relationships, and your bank made you buy crop insurance, right? Crop insurance in the United States is a federally reinsured program. So you swore to the federal government under penalty of perjury in crop year 2013, I made 100,000 bushels, right? Everybody knows what I'm talking about. That's a great document for a lawsuit. Why? Well, number 1, it's credible. You signed it before you ever heard about the Syngenta case. You signed it before you ever met Michael Watts. So that's good. Secondly, it's uber critical because you signed it under penalty of perjury. There's no reason for you not to tell the truth, right? So that's a great document. So we're going to get the crop insurance application forms for each of these crop years. But then Syngenta might say, well, that shows how much you produced. How much did you actually sell? So in order to get that, we're going to go down to the grain elevators and get you to get us the year-end summary reports. I don't need the slip receipts. I need the summary reports. You brought in 46 trucks this year. Here's what I paid you on each of these dates. Now, with those 3 documents, basically, I'm going to have documentary proof of the number of acres that you produced of corn, the number of bushels you produced, and the number of bushels you sold and what you got, right? So we'll need those for 4 crop years, 2 years before, 2 years after. So for crop years 11, 12, 13, and 14. And eventually, at the end of this year, we're going to need them for 2015 as well, okay? Now, that's basically the documentation we're going to need to be able to prove your case. So we'll compile all of that, we'll data enter it, and we'll fill out what's called a plaintiff fact sheet. This is a court-ordered document. It's about 2 or 3 pages long. It's going to ask you stuff like name, address, phone number. It's going to ask you stuff, from the standpoint of, how many bushels did you make, and you'll just swear that it's true, okay? So this client cooperation thing in paragraph 2 is basically you're going to help us get the documents we need, and you're going to help us fill out the plaintiff fact sheets, okay? Paragraph 3, the fee. All right. There's an old way and a new way to pay lawyers in this kind of case. The old way is you go into some lawyer's office and you agree on a rate, $250, $300 an hour. If you're closer to New York, it's more like $800 or $1,000 an hour. Well, a lot of people don't like that, and I don't blame you. I mean, you get some guy that's sitting in his office, he's keeping the clock. He's billing you whether he's losing your case, winning your case, wasting your time, or what. And every month you get a bill for some astronomical sum. You don't know whether you're winning your lawsuit or not. You just know it's coming out of pocket, and people don't like that. And I don't blame you. So what we do is we do it based on the new way. It's called the contingency fee, and it's designed to put our economic interests in alignment. Let's start off with number 1. We're sitting here at a meeting that I organized, I invited you to. I'm telling you I think you ought to do this. Why should you have to pay for that? Why shouldn't I have to put my money where my mouth is? Well, I should, so I will. We're going to cover all of your expenses in this litigation, okay? We're going to pay for your filing fees. We're going to pay for your expert witnesses. We're going to pay for depositions, travel costs, trial costs, everything, the full boat, okay? In that Rice litigation, we spent almost $4 million before it was done, okay? In this case, we're going to spend $10 million easy. I've already spent $4 million, all right? But if for some reason this turns out differently, I'm not going to send you a bill for $1 of my time or $1 of those expenses I put out. Those are my risk dollars, okay? But if we're successful, and I think we will be, and we settle the case, and only you can decide to settle your own case, for every $10 we get you, you'll keep $6. 4 will go into a pot with which we'll repay all these expenses, and whatever's left, our 2 firms will split under the percentage that's contained in the document there in paragraph 3. Does that make sense? Now, paragraph 4 is just a restatement of what I just said, and that is that all this accounting on expenses, it comes out of our 40%, not your 60%. So, what's the deal? It's a 60-40 no-risk deal to you, okay? Paragraph 5, multiple clients. This is another one of those lawyer rules, and it goes something like this. The lawyer rules say, look, it's fine for one lawyer to represent a whole bunch of different people in the same kind of lawsuit, but you owe them the courtesy, the disclosure to tell them that, okay, and to get their permission that you can represent a bunch of people at once, all right? So how do I comply with that lawyer rule? Well, every day I get a little computer thing that's sent to me telling me how many clients we have. As of this morning, it was 14,487 farmers and grain elevators. So that's been disclosed to you. If you sign this document, you're giving me permission to represent you together with that. Now, I want to predict for you, there are 22 teams doing meetings today in 20 different states. Okay? That number's going to grow by about 1,000 farmers a week as long as we're doing meetings. All right? You want that to happen. And here's why. That Rice lawsuit I told you about, I always like to tell the joke that, look, they didn't come to Michael Watts and ask me to negotiate the nationwide settlement with them because of my good looks or my full head of hair, okay? They did it because I represented the most farmers. My partner and I had the most trial settings. We had litigation pressure on, okay? That's why they came to us. If you sign this document, you will be in the largest litigation group in the country. As I mentioned, as of yesterday, 14,487. I don't know what it'll be tomorrow. But what I do know is we keep track, there are computer services, as to who has filed lawsuits and who hadn't. Okay? You can type in Syngenta, it's called PACER in federal court, the Minneapolis courts have it as well, and you can figure out how many claims have been filed. Okay? As of last week when we checked it, our group had filed over 11,000 farmers' claims. The next biggest group was about 350. So we're 30 times bigger than anybody else in terms of filed lawsuits. okay? So that's paragraph 5. Paragraph 6 tells you where I'm from. That's where you can sue me if I mess up and fail to file your lawsuit on time. But that's not going to happen. You remember that circle I asked you about to draw around that other thing? I'm going to explain how we're going to keep that from happening, okay? Paragraph 7 is another lawyer rule, and basically all it is this. There's a lawyer rule that says I'm not allowed to come knock on your house door and ask to represent you. That's called the illegal solicitation. I am allowed to send you a letter. I'm allowed to put an ad in the paper, invite you to a public meeting where we can talk about it at a public place. And that's what we're doing. You're just acknowledging you met me here at the library. I didn't come knock on your door, okay? Now, if you sign that document, step 1 of the lawsuit is over. I have my permission slip. Step 2 is the bottom of that page. You see the blanks that you need to fill out? Those blanks are basically 2 categories. I need your contact information. Name, address, phone number, email address if you've got it and you're comfortable giving it to me. I'm not going to sell it, okay? The bottom line is I'm going to send you status letters every 90 days at the end of every quarter. If I can send it to you via email, I can link documents and show you a lot more stuff. You can actually see the papers and stuff like that. Otherwise, we'll just slap a 49-cent stamp on an envelope and go that way, okay? Category 2 is tell me about your farm. I need the name of the farm, whether you're farming individually, as a partnership, as a corporation, or in a trust. I need where you farm, county and state. And then down at the bottom, you'll see that I ask you for an estimate as to the number of corn acres that you grew in 2013 and 14. Now, let me make something clear here. It says an estimate is sufficient, and it is. If you tell me, hey, I did 250 acres in 2013 and I get your FSA 578 2 months from now and it says 238, I'm not going to be sour with you, okay? This is an internal estimate only. And what I'm trying to do is when I file legal papers, I say something like this is being filed on behalf of 14,487 farmers who collectively grew 6,658,000 acres of corn, something like that, okay? I just need your best estimate. All right, so you fill that out. We've got the permission slip done. We've got the basic information done. Step 3 is I'm going to file your lawsuit. So what happens to that form when you give it to me, or you see down at the bottom, you can scan it and email it, or you can mail it in, okay? All those things go to the same place, and it's my office in San Antonio, Texas. There is a room there that's about as big as this bank. It's got 100 some odd people, and I don't know how many people, but it's a lot, okay? And all they do is they take several hundred of those forms a day, and they turn them into lawsuits. We will file your lawsuit by the end of the month. The reason I know that is 2 things. Number 1, I've already written it, okay? We're just putting your information into that page and filing it. But number 2, those 100 people, their only job is to do what I tell them to do, and I want to be sure that we file each and every one of these lawsuits on time. So this is why I had you circle this, and here's what I want you to know. In addition to some lawyer from Texas you've never met promising you he'll file it, here's how I'm going to show you that I'm going to meet that promise, okay? My commitment to you is at the end of every month, we're going to send all of our new clients for that month what's called a welcome packet, okay? It's a letter, it's signed by me, it's already been written, and it says welcome. It's got 3 purposes. Number 1, welcome. Here are the people in my firm that you're going to be dealing with us on this case. Here's who you can call with questions. Here's who you can send the stuff to. If you need to get a hold of me, I'll be out here, but they can get you in touch with me, okay? Purpose number 2. Hey, Watts promised me that he would file my lawsuit by the end of the month. Well, what's the best way I can show you that I did that? Send you a copy of it. So attached to that welcome letter will be a copy of your lawsuit, okay? Now, I want to warn you, the clerks in Minnesota are so far behind, they've asked us to file them in group of 80 and 90. So you'll be in an Exhibit A, you'll be a list of a bunch of names. Just make sure your name's in there with your farm name, okay? If it's there, we're good. And then the third thing is I'm just going to remind you, hey, remember I told you need these 3 kinds of documents? FSA 578, crop insurance application form, grain elevator summary report. Start getting them, and here's where you send them in, okay? So how does that make sure that we filed the lawsuit on time? Well, this is where we got to work together. You hold on to that piece of paper with the address that's circled, okay? You call him. If we get to about July 10th and you don't have a welcome packet from me, I want you to call him and say, that lawyer promised me that he would file this lawsuit by the end of the month and send it to me, okay? He's going to take your name and this town, and he's going to call me immediately. Watch, boy, you laid it down on the line. You promised these guys. And I'm going to call my older brother who runs my mass tort operation, who is a computer genius, and will have a database on his laptop wherever he's at. I'm going to say, here's the farmer's name, here's the town is, where is it? two things are going to happen. He's going to find a data, with your name on it, and it's going to say mail went out last Tuesday. It's just the U.S. mail taking their sweet time, but I'm going to be able to tell you that. It'll be there within 3 days. It's in the U.S. mail. It got dropped last Tuesday. Or, and this has only happened twice in 14,000 times, he's going to say, it never came here. Okay? Now, if that happens, we're going to immediately call Nate and say, Nate, where's the contract? We didn't get it. Okay? This has only happened twice out of 14,000 people. It was a meeting that I had in Aberdeen, South Dakota. The lawyer that was the version of Nate put it in his truck, and it slipped between the seats, and it was still there when we went looking for it, okay? But my point is, this trap makes sure that you're going to get that letter, and then you call us if you don't get it, and then we make certain that we get it, okay? Nobody's putting things in pickups anymore. Okay, so the bottom line is you're going to get the letter, all right? When you get that letter, you're going to know that your lawsuit's been filed on time. So step 3 and 4 covered, okay? Step 5 is you got to get me those documents, all right? You get me those 3 kinds of documents, you send them in, we fill out that plaintiff fact sheet that I told you about, you sign that this is true, this is the number of bushels I've produced. Once you do that, your work is largely done. Okay? My work then begins, although it's already started. We're going to review hundreds of thousands of pages of documents together with other good lawyers, find all the smoking guns, get all ready to go. We're going to take 100 to 150 depositions. My prediction is those depositions will start at the end of the summer. It'll last for probably a year and 4 months. We'll start the trials probably January of 2017 is what's being negotiated right now. So we're just going to get the case ready for trial. So that leads to the obvious question, hey, if I sign this piece of paper, do I have to go to trial in Minnesota? I don't want to do that. I'm a farmer in Nebraska. Well, here's the honest answer. It's not likely. It could happen, but the odds aren't likely, and here's why. As of now, call it 15,000 people are in the suit. Let's say that number goes up to 50,000 by, harvest. Well, I mean, if 50,000 different people file suit, there's not enough courtrooms in America to try all those cases, right? So this judge in Minnesota, his name is Thomas Sipkins. This judge in Kansas City, his name is John Lungstrom. They're not even going to try to trial. They're going to say, look, plaintiffs, Syngenta, we'll try 5 over here in Kansas City. We'll try 5 over there in Minnesota to give you guys a snapshot about what the juries think. Okay? So we'll go try 5 or 10. If my numbers are right, your odds of going to trial are about 5 or 10 out of 50,000. Okay? Feels like a bolt of lightning, but if you get struck, it's not the end of the world. If you want to cut those odds in half, when I ask for volunteers, don't raise your hand. Okay? But if you get picked by Syngenta, we'll come right here to your hometown. We'll put you through a 1-day deposition, not during planting, not during harvest. Okay? It won't be any big deal. If we happen to go to trial in Minneapolis, we'll cover your costs to go up there. You'll get to know me and my staff. We'll all become friends. You'll like it in a twisted sort of way, okay? But your odds aren't great that it's ever going to happen, okay? So how does the case settle? Well, we try 5 or 10 of the cases. We get a snapshot. 5 or 10 different juries tell us what they think about the case against Syngenta, what the damages are that they caused, if they caused it, okay? Then we get locked in a room. Judge puts us in there, locks it up, takes the key, throws it away, and says, I'm not calling the locksmith until you guys come out with a settlement agreement. So they put a lot of pressure on you, okay? So we start negotiating the settlement. Normally in an auto accident case or something like that, you'd have lawyers from each side and the clients from each side. But if you got 50,000 people, I mean, it's kind of hard to get a room big enough. I mean, what are we going to do, rent a football stadium? It's absurd. So that's not the way we're going to do it. We'll do a mediation. We'll let you know we're starting the mediation, but we'll negotiate provisionally. And what that means is something like in the Bear deal, I'll start off pounding on my chest, we won 6 in a row, pay us $3 billion. They'll start off, oh no, we're going to get all 6 of them reversed, we'll pay you $3. I'm making both numbers up, but we start off high, they start off low, we haggle over the weeks, and then eventually we get to a number that everybody agrees is a reasonable reflection of what the jury said the case was worth. Okay? In the Rice lawsuit, that was $750 million. Now, the fact that I thought $750 million was reasonable is not the test. You have to. It's your case and only you can settle it. This isn't one of those class actions where you get something in the mail that says your case is settled, here's your coupon. Okay? This is your lawsuit. So how do we do that? Well, we negotiate provisionally. Bayer, in that case, obligated itself to fund $750 million, but it was only contractually binding if I could get 85 or 95% of all the farmers to agree to accept it in writing. Okay? It's called the opt-in process. It's a high participation rate threshold. Let's say it's 95%. How do you get 19 out of 20 people to do anything? Well, you bring them a good deal. Okay? So we'll have a bunch of meetings, probably have a PowerPoint, bigger room than this, and we'll take you through it and show it what it means to you. Show you what the juries did, show you how we got there. We'll recommend it, and then you're going to have to vote it up or down. Okay? If there were 20 people in this room, 19 of you, everybody's got to say yes. We get to 95%, you could say no. The deal will still go through. If it's $1 billion, just to use a round phrase, your percentage of the settlement would be your number of bushels divided by everybody else's. There's other things in there, but at its core, it's your proportionate share, okay? But we could pull you out, set your case for trial, let all those guys settle, and then, you know, they either settle or try your case depending on what you want to do. Okay, that's what happened in the rice case. The best evidence that I can give you that we cut a good deal in that rice case is there were about 11,000 rice farmers that were eligible for that settlement. 10,999 said yes. Okay? That's a good settlement. One guy said no, and that's because we talked him out of it. We said, say no. He was more of a rice hauler than a rice grower. He had transportation damages that nobody else had. And so it wasn't properly accounted for. Just said, pull it out. We set his case for trial, got within about 3 weeks of trying his case in federal court in Victoria. Bayer came down and paid it under a completely different circumstance to everybody else. But the key is each and every farmer in America gets to make his own individual choice as opposed to being told what he's got to do. Okay? All right, so I'm going to open it up to questions. Let me go ahead and answer 4 questions I get asked in every meeting. So just cut to the chase. How long will it take? Here's my best prediction. You remember how I told you I thought that somewhere 50 to 100,000 farmers would file suit on time before this statute of limitations that each state has says you're out of time? Well, the major corn producing states, I mean, you guys, 5 of you produce about 50% of the corn in the United States, you know. Iowa, Illinois, Nebraska, Minnesota, Indiana. Well, there's a 2-year statute of limitations in Iowa, Illinois, and Indiana. So that leaves you guys in Minnesota. Well, Nebraska has a 4-year statute, okay? So why would they ever start offering money if they can have only 50,000 people file suit and there's 456,000 people on that mailing list is the way I got your address, so they could walk 406,000 claims paying $0. That's the logical move, okay? The problem is here in Nebraska you have a 4-year statute of limitations, okay? So my expectation is it's going to be deep into 2017 before the settlement pot is hot. And what I mean by that is we'll probably start trials in January 2017, have 5 or 6 test trials done, be getting to the end of Nebraska's statute of limitations, and then everybody's going to be talking, okay? So we're going to be deep into 2017 before, my prediction, we're going to have any good news for you, okay? What's the case worth? Well, that's an even harder question. And what I tell people is a lawyer that tells you what he's going to get you on first base is either a liar or a fortune teller. You know, they've got a crystal ball that I don't have, even though my 18-year-old daughter says I wear one on the top of my head. Okay? The bottom line is I don't know, but what I can tell you is what I do know is this. I know the price was $7.02. I know it went down to $3.25. I know through the principle of subtraction, that's a $3.77 difference. I am not telling you you're going to get $3.77, not even close, okay? Because I'm not going to ask for it. We all know that there was a big drought in 2012, bumper crops in 2013 and 14. We were in a heavy supply situation. We can't say this was all Syngenta's fault. But what the economists will say is this: when you're in a heavy supply situation, the single worst thing you can do is strip demand by getting rid of an export market. It'll cause the market to freak out. And that's exactly what happened. Commodity that's at $7.02 for almost 18 months. The day that the bad news happened about China destroying shipments, short sales, price goes in the toilet. So they're going to say it's a precipitating cause of the drop.
Right? I don't think I'm going to have any harm, and there's some industry reports out there, it's 11 cents a bushel. There's people that say 50 cents a bushel. There's people that say $3 a bushel. You know, I don't think I'm going to have any problem with a straight face telling this jury, you know, I think it's a third Syngenta's fault. It's more than $1 a bushel. Now, whether I get it is a whole different question. I can tell you that in the Rice lawsuit, largely the plaintiffs got what they wanted in 5 out of 6 of the trials, okay? But we'll have to wait for those 6 or 7 trials to see what the average is, and that's what the case is worth, and I can't give you any more detail than that, okay? Now, who can file suit? Well, it's pretty much anybody involved in the production or distribution of corn that lost money from the drop in the corn price. Farmer. Did 100,000 bushels, to use my example, was getting $7, now getting $3.50, you get the claim there. Landlords lease out their land on a share crop relationship, whatever their percentage is, they lost the same as the farmer in that percentage. If it was on a cash basis, you're really going to have to show that the cash rent dropped as a result of the drop in price. It did happen a lot between 2013 and 14. We got a lot of landlords that were getting $100,000 a year, and the poor farmer comes back and says, I can't pay you that. I'm underwater, you know, at $3.50 corn. I can only pay you $50. Well, in that case, you'd have a claim for the $50,000, okay? We represent grain elevators who lost money in 2 ways. A lot of them have a margin of, say, 15 cents a bushel, everything they process. When the export market fell apart, too much supply, you're selling to the same people, the margin went down to 7 cents, they got a claim for 8 cents a bushel, okay? Other grain elevators have a claim because they buy all of their corn on hedge. I'll pay you everything you can bring me at $5 a bushel, guaranteed. The reason they're doing that is they think that they can flip it to Cargill and ADM at 6. When it goes to 4, they lost money. Cargill, ADM, Transcoastal Supply, the exporters, they're buying everything they can get at 6 because they know what their transportation costs. They can take it to, you know, wherever and sell it at 8. When it goes to 4, they lost money, which is why they filed lawsuits. Pretty much the only folks that made money on this deal, you know, like my client Valero, I mean, their cost of supply went way down, right? So their margins went up, they killed it. I do represent some ethanol plants, but it was usually ones that bought all their corn on hedge contracts and they got bit by their hedge contract, okay? Last issue, who has to sign this piece of paper to have a binding contract? It depends on how you farm. If you're an individual, you sign it, we're good to go. If you're in a partnership, you sign for your share. If you're in a 50-50 partner with your brother or something, you sign for your 50%, he signs for his 50%. You can do it without him, he can do it without you, but you can only recover your 50%, okay? If you're in a corporation, your farm's held by a corporation, whoever the president, CEO, officer with authority to bind the company signs the contract, the corporation is the client. We pay the corporation, who then distributes it out via dividends, whatever the corporate agreement is. Lots of farms are held in family trusts. You know, we've already been taxed once. When I die, I really don't want to lose the farm to the federal government, so we do these trusts, right? Nothing wrong with that. Whoever the trustee is of the trust, and he's to sign the document, the plaintiff will be the trust that holds the farm. We'll pay the money into the trust, benefits, you know, whatever the beneficiary documents say, okay? So why don't we just fire it up and ask any questions you got. There's no bad questions at all. I've tried to answer the 4 main ones, but what other questions pop to your head? Go ahead. Yes, sir.
On these FSA forms, crop insurance forms, and the elevator, do we need 11, 12, 13, 14?
Yes, sir.
All 4 of them?
All 3 of them, yeah. 12 documents in effect, yeah. Okay.
What if you didn't take federal crop, you just took like rain and hail through?
Yeah, I mean, obviously you can't give me something you don't have, okay? So if you don't have crop insurance, I mean, you didn't fill out a crop insurance form, you can't produce one, you know?
Yeah.
So, you know, but if you did have rain and hail and you've got that same information in there, so give me that instead. You know, what we're looking for is contemporaneous documents that prove 3 things. Number of corn acres grown, number of bushels produced, number of bushels sold, what you got for it. Okay? The 3 that I'm telling you about are the gold standard, that's what we want. But if you can't give me something that didn't happen. If you got a next best thing, send me that instead. Okay? Yes, sir.
What about the person that feeds a lot of their grain?
Okay, silage. I don't know what the answer is, but here's what the argument's going to look like. I'm going to say, look, but for Syngenta's actions, you grew 100,000 bushels of corn that has a value.
The value should have been 7, it went to 350. Your lost value was 350, for whatever the cause is, okay? And what you choose to do with that is your call. It's your property. You can feed it to your cows, you can store it like a lot of people have done, or you can sell it. So the fact that you didn't sell it doesn't make any difference. Now, let me put on my devil's advocate hat. I'm Syngenta's lawyer. Well, wait a minute, you sold that to your cows. That cow doesn't know the difference between $7 corn and $3.50 corn. I guarantee he can't taste the difference. So you're going to get some of that, okay? But it's going to be on a person-by-person deal. I don't think it makes a difference, but Syngenta is going to claim it will. And I'm going to say, well, look, they fed it because they couldn't sell it for anything. The cost of feed went down, so of course you're going to feed more of it. Same deal on stored corn. This is why I like to go back 2 years before. If you grew corn in 2011 and 12 and you had it in one of your silos when the price fell, you got hammered, okay? So we'll go back and get that production, and in effect, the reason I want the 3 documents, we want the FSAs because everybody wants them, okay? We want the crop insurance or the like for it to show bushel production, and then this is bushel sales in terms of the grain elevator. So the difference is it didn't go anywhere, it didn't get stolen, it's either being stored or it got fed, okay? What other questions? Yes, sir.
So if you cut like corn silage.
Yeah.
And so many acres of corn silage, do you put like what that field, the rest of that field yielded if you didn't cut that whole field?
No, what I want you to do is give me your production numbers in toto, okay? We'll get down to cutting it down, into the details later when we get to the plaintiff fact sheet. Statistically, I think I read, and if I'm getting this wrong, I apologize, I think there were about 90 million corn acres grown last year. Only about 4.5 or 5 million of them were cut for silage, which was lower than I would have thought. So we'll just have to figure that out on a farmer by farmer basis. But we're going to get the total production, and then we'll start parsing the onion just like you two guys have asked about, okay? What other questions? Yes, sir.
Question. If I sign this here, does this get filed in Nebraska?
No. Well, if you want me to, I will. But what my plan is I'm going to file it in Minneapolis. Okay? But if you really want me to file it in Nebraska, file in Nebraska. What's going to happen to it? Well, it's going to get removed to federal court. It's going to get shipped to Kansas City, and it's going to be in this MDL proceeding that's got good lawyers, but basically it's a class action thing going on over there. I've got an agreement with those guys that we're not part of their class action, and frankly, I think that, if anybody was involved in that Starlink mess, where lawyers got millions of dollars and you got a coupon card at an implement dealer that averaged $250 a piece. I don't prefer the class action. I prefer the individual one by one, and I think the results show the difference, okay? But if you really want me to file it here, I will.
I was just kind of wondering, because
Yeah.
I've been told that if you file in Nebraska, the client has to pay the filing fees.
I don't know about that, but
I wondered how because you said you paid the filing
Yeah.
fees, and I was just wondering.
Yeah. Well, I'm not filing any in Nebraska unless I'm told to, and then I'll look that up. But he's not familiar with that either.
I wouldn't know any reason why you would have to pay filing fee. No, that's not that
Yeah.
wouldn't be the case.
Well, and you may have some lawyer that doesn't want to pay him, and he's trying to give you a line of bull about how I would do it if they'd let me, But
I've seen contracts where you are writing checks to the lawyer, so don't do that. Yeah. So, yeah. So no, there's no filing fees.
what other questions does anybody have? Yes, sir.
You spoke mass action versus class action.
Yes, sir.
Where does it, I'm a slow reader, where does it say that it's mass action?
Okay. Well, let me. I don't know that the contract itself says that. If you want to write mass action, not class action, I'll initial it right now. Okay. But the bottom line is, I am not a class action lawyer. I can tell you a couple of things. I tell people, some guys bring a bunch of these things that have all populated their mailbox. How do I tell between you and somebody else? And what I tell them is this. I said, number one, I would ask the question, what experience do you have in this kind of lawsuit? Okay? And the bottom line is that the number of people that were involved in that rice case, you could count on 2 hands. Okay? I think there's only one of us that could pull out of this computer right now and show you 200 emails between me and the bear lawyer negotiating the settlement, but that's neither here nor there. But experience matters because, if you were going in for an open heart surgery, There may be the best doctor in town down the street that opens up knees all the time and does knee replacements or whatever, but just me, I don't want to be the first chest he ever cracks open. Okay, and there's all sorts of landmines in this kind of stuff, so I'd ask about experience in the Rice case, okay? Number two, you want to make sure this is big boy litigation here. We're suing a company that just turned down $45 billion from Monsanto. Okay, you got to make sure your lawyer's got the juice to be able to play in this kind of arena. I had a guy at the last meeting say, oh, the lawyer says they're going to sit back and wait and they're going to be in the third group. What does that mean? That means I don't have the money to file the lawsuits. Okay, so you might ask, how many lawsuits have you filed against Syngenta? It's a polite way of asking, are you holding on to lawsuits because you don't want to spend the money? And I think that's an important question to ask. And the third thing I would ask is, look, show me a list of all the cases you've tried. Don't tell me you tried a bunch. I want names, amounts, all this other stuff. Because you got a bunch of people around there that are pretending to be trial lawyers that are really paper pushers waiting on trial lawyers to do the work. Okay? What other questions? Going once.
These, the FSA form and all this.
Yeah.
This is the first step you do.
That's right. I don't need any of those forms right now. But basically the process, you fill out that deal. It's on one page. You can fill out right here. We'll take it. We'll scan it in, or you can mail it to me. Either way. Okay. Step two, I'm going to take that form. I'm going to file the lawsuit. Okay. Step three is I'm going to send you a copy of it in that welcome packet, and in that welcome packet I'm going to remind you, these are the 3 documents I need, these are the 4 crop years, go get them, okay? You don't need to do it right now, okay? Now if you wanted to start, it wouldn't break my heart, but I don't need it right now. Yes, sir?
How soon do we have to have these forms back to you?
There's not a deadline yet. You're going to get a letter from me towards the end of the month asking for them, and then the sooner you can get them, the better it is for you, because I've got 100 people that all they do is call people all day. I'm still missing your 2012 SSA 578. Can you get, and I don't want to bug you guys. If you just think about 12 documents, 3 kinds of documents, 4 years, and then again, at the end of the year, I'll call you back and get the 2015 version of it, because we're going to want to supplement your damages to make that claim. But there's no deadline yet. Eventually, we will get a court order for a plaintiff fact sheet that will ask for all this stuff, and they'll say, do it by X date. Okay, and I know that's coming, so I'm just collecting them now. Okay, and we're getting them all data entered and getting it all ready, and everything's electronic, so and we'll just go through. Hold on to what you send me, so you got a copy. And most of you guys had to round most of this stuff up for the Farm Bill last year, anyway. Okay, which is a good thing. I don't know what your view is about the Farm Bill, but for me, when in Rice we asked for all this stuff, and the people looked at us sideways. Here, everybody, oh yeah, no, I got that for the Farm Bill, so that's good. Any other questions? Yes, sir.
Will you be kind of like in with all the other lawyers, at the very end, representing all the farmers?
No, I'll represent the people I represent.
They all get the same settlement, though? Each lawyer gets
it depends on the case, and let me tell you what I mean. When Bear came to me in the Rice case and said, look, we want to do, a master deal. We weren't able to do it as one, we did it as 2. But, that was kind of a deal because there were so few of us doing it. There's so many people in this corn deal trying to do it. A lot of them are rounding up cases, sending them to me, this kind of stuff. But for example, have y'all heard about, and I hate to talk about this, there's a product called transvaginal mesh. It's been all over the TV, and all these women, 120,000 women have filed suit. They're not doing it all at once. They're going to the law firm with the most and talking to that person first. Then they go to the one with the second most, and they're just going down the tail. If you're with the local firm that's got 3 lawsuits, you're going to be way in the back of the line, okay? In order to get the guy first to settle, they give him what's called a most favored nation status. You have no risk of somebody coming on and doing a better deal if you've got a most favored nation status. So, the bottom line is that I think you want to be with a big group that's got some staying power, okay? I don't know whether I fully answered your question. Are you still looking at me like maybe I missed it?
I just thought maybe all the lawyers.
Sometimes it happens that way. A lot of times it doesn't. Okay, and my experience is when it doesn't, big groups settle first and for the most money, and it just kind of tails down from there. But it may be like Rice, where I just said, yeah. I mean, we had so many of them. We just said we didn't care. Just offer it to everybody, whatever. Anybody else? Okay, one other thing I want to tell you. There is a big stack of these that you can grab on your way out, okay? I am fully aware that each of you has 15, 20 people that are not here. You got farmers, you got landlords, you got partners, you got friends. I always tell the joke, I like the 8:30 meeting with the farmers the best because you guys are constitutionally incapable of climbing on a tractor until you've had coffee with your buddies. You know, go talk to your buddies about this, okay? The one thing I would tell you is this. If you go to the thing that I asked you to circle down at the bottom, it says NebraskaLostCorn.com. There's a website there. You can go on that website and sign up. They don't need this piece of paper. They can do it electronically on the website. They can go on there. I don't know whether it's on there right now, but after I stopped doing meetings so that y'all could go plant. The last meeting was April 17th. We started up again on June the 1st. During the 6 weeks, we had a bunch of planning meetings about how we're going to do 2,000 more meetings between June the 1st and October the 15th. But one of the things somebody came up with this idea, why don't we write down all the questions you've been asked and write a little article about each so that somebody can go on the website and see that. So if they're not on there right now, we'll have them on by the end of the week. There's 50 articles that I wrote, 500 words apiece, that answer 50 different questions that I've been asked about this lawsuit. And I'm going to keep adding to them. So feel free to go root around, tell your friends to root around on this website. They can sign up there. 43% of the 14,000 people we represent never attended one of these meetings. It's a friend, a neighbor that got told about it, went on the website, signed up. Okay? So take as many as you like. I try to quit in an hour, so I'll be outside answering any questions anybody's got. If you guys want to fill them out, have at it. That's why we got pens. Otherwise, grab as many as you like or tell him how many you want. And I appreciate y'all all coming. Thank you.